Got a question asking, what's the next step after a 30-day notice is issued and the tenants then surrendered the property? What happens next? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I got to give you the lawyer's answer, and it's going to highly depend on the particular landlord's situation, tenancy, and how long a tenant has resided there, because these are all things that could play into this equation here, okay? So, assuming that this is a tenant, it's an actual paying landlord-tenant situation in California, and assuming that this tenant hasn't resided in the property for over a year, 365 days or more, and this landlord does not have to have just cause under the State Tenants Protection Act. You wouldn't have the tenants don't get just cause protections until they live there a year, but under a local ordinance, as long as you're not required to have just cause, this landlord could possibly give a 30-day notice to vacate, assuming it's a month-to-month tenancy or less. Okay, if it's a fixed term lease agreement, you can't give a 30-day notice to vacate. Certain tenancies, like a tenancy at will, where there's no agreement to pay rent whatsoever, can the law says under Civil Code Section 789, you can give a minimum of 30 days notice to terminate that tenancy. Okay. That being said, if this is a tenancy that you can give a 30-day notice on, then you can basically start the unlawful detainer process. Okay. If this tenant has lived there for more than a year and they, what we call in legal lease, hired the property, meaning they're like renting the property and they're paying money or other forms of compensation to live there, services, that type of deal, they may be required to give a 60-day notice to vacate, at least under state law. And if you're a participant of the Section 8 Housing Voucher Program, you're going to have to give 90 days notice under the Health and Safety Code. So those are kind of like some of the caveats and pitfalls about this answer. The answer would be file an unlawful detainer, but my lawyer answer would be probably need to talk with a landlord tenant attorney to make sure everything has been lawfully terminated. You have the right, you gave the right notice, it has all the right language in it, and so forth, because you could go ahead and file this in court, for example, and then your tenants go file what's called a demur. Basically, it's a challenge to the unlawful detainer complaint, basically stating that, hey, the landlord doesn't have a legal right to terminate my tenancy with a 30-day notice, for example, because you're required to give a 60-day notice. Or you have to have just cause, and this notice doesn't have just cause. So that's kind of what could happen if you issued the wrong notice or if you don't have cause, for example. So it's probably best to talk with someone and go over these things out. Better yet, better to probably talk with someone before you issue the notice to begin with, so you don't waste a bunch of time or effort or risk getting called out for violating some type of eviction ordinance or the state's Tenant Protection Act. So those are my thoughts here. But the next step would be, if everything was legal, you could start the eviction. Okay. Landlords in the Northern California area, if you have this question and you're thinking, I don't know if I did everything right according to the law or my local ordinance, feel free to reach out. We might be able to help out. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.